State of Michigan versus Mark Anthony Silvertooth. We are here today for an arraignment in this case, and we are proceeding today by video conference. First, may I ask the attorneys to place their appearances on the record, beginning with Mr. Hartung for the people.
Thank you, Your Honor. Good morning. Doug Hartung appearing today for the people.
Good morning, Your Honor. William Amadeo, P7619, on behalf of Mark Silvertooth. We both appear via Zoom and consent to such. And thank you for that. Mark, please state your name for the court to know it is you on Zoom.
Mark Anthony Silvertooth.
All right. Yeah. Mr. Amadeo, does Mr. Silvertooth wish to have the information read?
No, actually, Your Honor, I apologize for not getting this waived earlier. I got sick, but we'll waive a formal reading, stand mute. And I think we have this matter ready to plea this week, Judge, but we do not need any formal readings whatsoever.
Okay, so you have a plea today?
No, Judge, we have a plea on the 29th, I believe. Friday.
Oh, I'm sorry.
Friday, and I'll get an advice of rights over to you and all, but I think we'll have this matter settled by then if that works for you, Judge.
So we'll enter a not guilty plea for now then and await the documentation on that plea.
Thank you, Your
Honor. Anything else we need to address today, Mr. Hartung?
No, I think it's this Friday at 9:30, I believe. I will be out of town, but I will appear by Zoom to handle the plea, Your Honor.
Okay.
That's correct.
Sounds good. Then we'll see you back on Friday at 9:30.
Thank you, Your Honor.
Thank you.
Cheers. Something. I have someone here that just was brought into the meeting on a Motorola Moto 5G device. I need you to unmute that device, please. All right, can you tell me your name, sir?
I'm Dwan Harris.
Okay, 1 second. All right, Mr. Harris, your attorney is not in my Zoom session yet. I'm going to put you back in the waiting room until he gets here.
Okay.
Mr. Glazer, I think I have Mr. Shears here. Do you need to speak to him?
No, I don't, Your Honor.
Okay, Mr. Shears, you want to come forward and sit at the table here, please? Okay, this is file 24-21752-FH and 25-22116-FH, People versus Frederick Shears. We're here today for a pretrial conference in both of those cases, and we are proceeding today partially by Zoom and partially in person. First, can I have the attorneys place their appearance on the record, beginning with Ms. Arnold.
Allison Arnold for the people.
John Glazer on behalf of Mr. Shears.
Okay, and Mr. Shears is here in the courtroom. Mr. Glazer, where do we stand with these cases today?
Well, Your Honor, I've got the search warrants. This was originally, gosh, I can't think, the attorney up in Jackson, it was his case. And I took it over. And I thought there was some discussion about a 404B and a consolidation. I've never received those requests at all. I don't know if Miss Arnold's planning on filing those and serving me with those, but that was the last thing we had. Other than that, uh, we could set a trial date and a motion date, but I don't know if she said there was I thought she said there was a 404B notice and a consolidation notice. It might have been sent to George Lyons who had it, but they're not in my file.
Judge, at the last hearing, I referenced that we filed the 404B notice back in January in the 2024 case. If Mr. Glazier didn't have that, he should have let us know. We originally had a pretrial in May of this year and adjourned it to the last court date to see if Mr. Glazier had any motions to file, which was August 6, 2025. I believe I probably put on the record at that time that we needed to decide whether he opposed the 404B notice and or consolidation of the cases for trial. If he didn't have the 404B notice, he really should have let us know.
Well, I think I did let you know at the last hearing. I don't have either of those. I don't have a motion to consolidate.
No, you did not. I would have sent it to you if you would have let us know that you didn't have it. I'm going to email it right now
Okay.
because I have that technology.
And I disagree with you. I did indicate that I didn't have it, and I don't have a motion to
All
consolidate.
right.
either.
I'm not gonna listen to you two argue about what was said at the last pretrial. That's not getting us anywhere. So how many days do we need for a trial?
Well, it depends on
It
if we're
depends
trying
on,
two cases or one case.
Judge, I've been trying to resolve this consolidation issue since Mr. Lyons was on the case. I just sent Mr. Glazier the 404B notice. One of the things on the 404B notice is if he objects to the use of the evidence, he has to state what his theories are for the court to make a meaningful decision about whether to admit the evidence or not if he opposes it. I mean, I can do a motion in limine on the 404B notice if the court would prefer, but I thought Mr. Glazier indicated that he was going to, at the last hearing, he indicated he was going to decide whether he opposed the evidence or not. So I think we need to resolve that issue first, because if the 404B evidence comes in, Mr. Glazier might not oppose consolidation of the cases for trial, which we still don't have an answer on.
All right, so I'm gonna set this for a trial, giving us enough days if the cases are consolidated and tried together. If we don't end up needing those days, then obviously we don't need those days. If Mr. Glazier wants to file a motion in the meantime regarding the 404B issue, he can do that. But this needs to begin moving forward to a conclusion rather than sitting in limbo as has been done for the last several pre-trials. So if this case is tried as a consolidated, if these cases are tried consolidated as one, how many days do we need?
3 days, Your Honor.
At least 3 days, Your Honor.
Then let's set it for 4.
But we need to set the motion for consolidation. If it's been filed, it should be noticed for hearing.
I don't know that I'm going to seek to consolidate the trials if the 404B evidence comes in. I may want to have 2 separate trials, but if Mr. Glazier wants to consolidate the trials, if the 404B evidence comes in, that's something I would probably stipulate to.
Oh, okay. I was under the impression you had filed a motion to consolidate. That's why I don't have a copy of it, because there wasn't one filed. I understand now. So it's just a 404B. That's fine, Your Honor.
Sergio, can you go grab the book off Francis's desk?
Judge, I don't know if the court wants to do this, but I believe the Stephen Maples trial, Mr. Noe told me yesterday he doesn't have a report from an expert yet. So that trial may end up not going. I think it's fairly likely we're going to have to adjourn that. If the court wants to set this as an alternate to Maples, I think that would get us an early trial date. And then we could set a motion date for me to do a motion in limiting on the 404B evidence.
When is Maples set?
Maples is October 21st through the 24th.
I've already got backups on those dates.
Oh, I'm sorry, Judge.
So I can do November 12th, 13th, 14th. That would be through the Friday, and then Tuesday, November 18th.
That's good for me, Your Honor.
I assume that's good for me, Your Honor. I'm not at my office. If there's a problem, I'll call the court right away today.
And Judge, I think if the court would set a motion deadline in 2 weeks, give it maybe opposing parties a week to respond and set a motion hearing date, I think that'd be appropriate.
All right, we'll do a final pretrial on November 5th at 8:15. The court will issue a scheduling order that will have motion deadlines and other pertinent information.
Judge, because of the consolidation issue, can we set motion hearing or another pretrial? Because we need the issue to be resolved fairly quickly, because I'll need to know who I need to subpoena for trial if we're going to consolidate or not, or depending on if the 404B evidence comes in or not.
We're not agreeing to a consolidation. If you want to file a motion to consolidate, I thought you said you weren't going to file one or you're going to wait.
Well,
so-
we have to resolve the 404B evidence. If the 404B evidence comes in, I'm going to need to subpoena the same witnesses basically I would if we had 2 trials. So we need to know, I'm going to need to know, in October sometime whether I need to subpoena more people or not. And that's a busy time of year. It might be hunting season. So the sooner we resolve the 404B evidence issue, the better. That's why I would request that we set a very early motion hearing date on that.
I'll set a deadline. It'll be in the notice.
Okay, thanks, Judge. And Judge, just one more thing. Would the court have an objection if we file a motion with us just noticing it for hearing?
I'm sorry. Just give me a
Would,
second. Okay, I'm sorry. What's your question?
would the court have an objection if we file a notice with us just noted, I'm sorry, a motion with us just noticing it for hearing?
I don't understand. Yeah, you can file a motion and notice it for hearing.
Okay. Thanks, Judge.
I mean, contact Francis to get a date. Don't just pick something arbitrary.
Right, I understand.
All right. Is there anything else we need to address with this case, these cases today?
No.
No, thank you, Your Honor.
Fred, you ought to come in and see me this week.
All right. Do I gotta call an appointment when you want me in
Yeah,
there?
call, just talk to my secretary, set up a time to see me this week.
Okay, you're all set, Mr. Shears.
All right.
Thanks, Judge.
Called you for Randy Torres. Okay, I have a device that I just brought into the meeting. The name is Hunter Bosher. I'll need you to turn the video on and unmute that device, please.
Hi, Your Honor. My name's Hunter Bosher. I'm a foster care worker with Catholic Charities. I'm here to observe Dwan Harris, Dwayne Harris's hearing that was scheduled for 8:15.
Okay, you can go ahead and just shut your camera off and mute your device then. And I think we're waiting on Mr. Harris's attorney to get logged in.
Thank you. I appreciate it.
Morning. Dunning. Say it again. Dunning. Thank you.
Okay, Mr. Sinclair, I believe I have Mr. Vargas coming into the meeting now. Are you ready to proceed with his cases?
Yes, sir. I'm ready.
All right, Mr. Vargas, if you're there, I need you to unmute.
Yes.
Okay. This is file 25-22317-FH and 25-22318-FH. People versus Jake Jr. Vargas. We are here today for pretrial conferences in both of those cases, and we're proceeding today by video conference. First, can I have the attorneys place their appearance on record, beginning with Mr. Bannett?
I'll explain that for the people.
And good morning, Judge. I'm Christopher Sinclair, 80512, appearing with it on behalf of Mr. Vargas, and we consent to proceeding via Zoom. And Mr. Vargas,
Okay, and
what's
Mr.
your name on the record?
Sorry.
Mr. Vargas, state your name for the record, please.
Jake Vargas.
Thank you.
Okay, and Mr. Sinclair, where do we stand with Mr. Vargas's cases today?
Yes, sir. So this is the first pretrial after arraignment. We waived arraignment in this file. I've been in contact with Mr. Bayonetto in this matter, and we're still kind of trying to work things out a bit. There's a little bit more work left to do, so I'm just asking the court for another pretrial and see if we can come to a resolution. If not, then we have to move toward a trial date.
Okay, Mr. Bayonetto, is there anything we need to address from the people's side at this point?
No, Your Honor.
Okay, let's see, we can set this then for another pretrial on October 1st, if that works.
Second, please.
That worked for the people, Your Honor.
Yep, as long as we're on Zoom, it works for me.
Yeah, that is on Zoom and that's it.
Yes, sir. Works for me.
Okay, Mr. Sinclair, would you be willing to do a stipulation in order for that adjournment, please?
Yes, sir. I can do that.
Okay, anything else we need to address with this case today then?
Not from the people, Your Honor.
Okay, thanks. We're all set then. Ms. Vargas, you can go ahead and log out. Your next date is October 1st at 8:15.
All right.
All right,
Thank
thank you
you.
so much and have a great day.
Thank you. Okay, I have a jail device logged into the Zoom session. The camera is off and the microphone is muted. I'm going to send you a request to start the video.
We just covered for Randy. Thank you.
How about that?
Mr. Glazier, do you need to speak to Mr. Torres? Mr. Glazier, if you answered, you were muted.
I need to speak with the prosecutor that's handling it. Is it Phoebe? Is she on there?
For which case?
For Torres, Randy Torres.
I believe that's me, yes. Yep.
Oh, can I just speak with her for, you want me to call you or you want to transfer me to her, Judge?
I can put you in a break.
All right.
Okay, Mr. Fry, I have Mr. Watson Clark here in the courtroom. Are you ready to proceed with him?
Yes, Your Honor.
Okay, Mr. Watson Clark, if you'll come forward and sit the certificate of television. This is file 25-22230-FH People versus Anthony Wayne Watson Clark. We are here today for a pretrial conference in this case. We are proceeding today partially by Zoom and partially in person. First, can I have the attorneys place their appearance on the record, beginning with Mr. Bayonetto?
Alex Bayonetto for the people.
Brian Fry for Anthony Watson Clark.
And Mr. Fry, where do we stand with Mr. Watson Clark's case today?
Yes, Your Honor. So Mr. Watson Clark is in the middle of completing the diversion program. He's actively engaged in that, is my understanding. He just needs more time to complete that. So we'd be asking for an adjournment of like 2 or 3 months, maybe.
Okay, Mr. Bayonetto?
Your Honor, I do see notes from Mr. Wendt that the defendant is making payments and making progress in diversion, so I wouldn't have an objection to an adjournment that far out.
Okay, so that would put us into late November. Let's go with November 19th at 8:15. And Mr. Fry, would you do the stipulation in order to adjourn the pretrial?
Yes, I can do that. Mr. Bayonetto, could I send your name to that with your permission?
You can, thank you.
Thank you.
Okay, anything else we need to address with this case today?
Not from the people, Your Honor.
Nothing further.
Okay, so Mr. Watson Clark, your next date is November 19th at 8:15 a.m. Thank you. You're all set for today. Thank you. Welcome. Okay, Mr. Glazer, are you ready with Mr. Torres now, or do you need to speak to him?
Yeah, I need to speak with him.
Okay.
Judge, something happened. Mr. Torres never was in the room with me.
All right, let me try to set that up once more. Okay, Mr. Torres, if there's something on your screen asking you to join a breakout room, you go ahead and accept or click yes.
Okay.
Okay, Mr. Decker, you want to come forward, please?
Which side I sit on?
You can either sit at the table here closer, or you can stand at the podium, whichever you prefer. This is file 25-52369-PP, Roland Peril versus Elijah Decker. We're here today for arraignment on an order to show cause for alleged violation of personal protection order. We are proceeding today in person. Sir, you are Elijah Decker?
Yes, sir.
And Mr. Decker, have you received a copy of the motion in order to show cause?
Yes, I do. I have it right.
The motion alleges that you violated the personal protection order in this case by smacking a cup of coffee out of the petitioner's hand. Do you understand that the maximum possible penalty for violating personal protection order is up to 93 days in jail or up to $500?
Yes, I do.
You are entitled to be represented by an attorney at this hearing today and at any other hearings that we have regarding this matter. If you can't afford an attorney, you can tell me that and I'll appoint one for you from the public defender's office. Do you understand that?
Yes, I do.
Do you want to be represented by an attorney today?
Feeling it safer, yes.
Okay. Do you have the ability to pay for your own attorney?
I do not.
All right. So what I'll do is have you speak with the public defender that handles these. She is not logged into my Zoom session right now. She's in Judge Anselm's court. So if you'll just take a seat back where you were as soon as she gets here, I'll have you speak to her.
Okay.
Judge, Mr. Attorney, we didn't hook up. He didn't appear in the breakout.
All right. We'll call the jail and get him some help to get to the breakout session.
Okay.
Please have Mr. Torres join us in the session. Thank you. Bye.
I want you to meet with your attorney, Mr. Torres.
Middle. Copy.
Mr. Glazier, we're supposed to be joining a breakout room with you.
Yeah, soon.
Yeah, 1 second. Give me just 1 second here. Okay.
Yes.
All right, Mr. Fry, I think Mr. Bouie is here in person. Are you ready to proceed with this case?
Yes, Your Honor.
Okay, Mr. Bouie, if you'll come forward and sit at the table closer to the television, please. This is file 25-22321-FH People versus Marcus Anthony Bouie. We are here today for a pretrial conference. In this case, we are proceeding today by video conference, and Mr. Bouie is here in the courtroom in person. First, can I have the attorneys place their appearances on the record, beginning with Ms. McClure.
PB McClure on behalf of the people.
Brian Fry, appearing for Marcus Bouie.
And Mr. Fry, where do we stand with Mr. Bowie's case today?
Yes, Your Honor, we would be requesting an adjournment of the pretrial. We are working on getting transcripts from the preliminary examination, and then, there'll probably be some motions filed after that.
Have those transcripts have been ordered?
I just looked at the file and I couldn't see that they were, but they will be today if they weren't.
Okay, yeah, I just flipping through, unless it was ordered down in district court, I don't see anything in the file indicating they've been ordered here, so. Okay, so if we're gonna wait on transcripts, that's gonna be 90 days. Let's go with an adjournment to December 3rd at 8:15, if that date works.
That works.
Okay, and Mr. Fry, would you do that stipulation in order?
Yes, I can prepare that. Ms. McClure, could I sign your name with permission?
Yes,
Thank you.
All right, and I'm sorry, Ms. McClure, I didn't ask if there was anything you needed to address from the people's side.
there is not. Thank you.
Okay, so Mr. Bouie, your next date is December 3rd at 8:15 a.m.
All right.
You're all set.
All right, thank you.
Thank you. Okay, Mr. Glazer, are you ready to proceed with Mr. Torres?
Yes, I am, Your Honor.
Okay. This is file 25-22298-FH and 25-22299-FH. People versus Randy Torres. We are here today for pretrial hearings in both of those cases, and we are proceeding today by video conference. First, going to have the attorneys place their appearance on the record.
E.B. McClure, on behalf of the people.
John Glazer on behalf of Mr. Torres.
And Mr. Glazer, where do we stand with Mr. Torres's cases today?
Judge, on the first file, 9-8, he's going to plead to attempted UDAA with the understanding of the habitual offender to be dismissed. On the other file, he's pleading to count 1 as a second habitual offender and the OWI with the rest of the habitual offender being dismissed.
So we're going to need an amended information in the 22298 case.
I think you might need an amended in both because of the habitual offender. I wasn't sure that he was pleading, so I hadn't prepared those. So if you just give me a few minutes, I can get those done.
Okay. Oh, gee,
Do you know what they're saying? Judge Alsafer? Okay, could Michael Goebel in now, please? Great, thank you so much. Bye.
While we're waiting for me to do these amendeds, can we get Mr. Torres' advice of rights so we don't have to wait? I assume he hadn't done that.
Yeah, thank you. Could you call the judge to take a minute question?
Would you be able to take the advice of what's supposed to read the toilets first to file?
Okay, Mr. Monterez.
Place the rates forms.
All right, Mr. Torres, the officer, I think, has handed you an advice of rights form. There should be one for each file. Take whatever time you need to read through that, and if you're comfortable with it, sign it at the bottom. All right, this is file 25-22173-FH, People versus Brian Merritt. We are here today for hearing on a motion in order to show cause related to bond violations. We are proceeding today partially in person and partially by video conference. Mr. Moners, would you like to place your, I'm sorry, Ms. McClure, are you going to appear on this?
Yeah, Your Honor, he also has a pretrial
Sorry.
for the underlying case. So Phoebe McClure may have the people filling in for prosecutor of record Isaac Sneed.
Your Honor, Nicholas Monrose on behalf of Mr. Merritt, who should be present via Zoom. Communicated with him earlier today. He indicated that he was online, but I don't see him yet.
Yeah, Mr. Merritt, can you start your video? I'll send you a request to do that.
Your Honor, while we wait for that, do you prefer me at the table at the podium as a matter to you?
It doesn't matter as long as you're in front of one of the microphones on either one.
Understood, sir.
All right, sir, you are Brian Lee Merritt. Can you hear me, Mr. Merritt? All right, so Mr. Merritt is there, but he's not responding. I'm not sure that he can hear me.
With the unchanged facial expression, Your Honor, I'd say probably not.
All right, so Mr. Moners, what I'm going to ask you to do is call your client and ask him to come to the courthouse in person.
Will do, Your Honor.
All right, Mr. Merritt, can you hear me now?
Mr. Merritt, can you hear us? Doesn't look like the
All
camera.
right,
Look at the phone.
Okay, Mr. Fry, are you ready to proceed with Mr. Goebel?
Yes, Your Honor.
This is file 24-21915-FH, 24-21916-FH, and 25-22117-FC. People versus Michael Ronald Goebel. We are here today for pretrial conferences in each of those cases, and we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Ms. McClure.
Phoebe McClure may have the people.
Brian Fry on behalf of Michael Goebel.
All right, Mr. Fry, where do we stand with Mr. Goebel's cases today?
Yeah, I think there's a few things, Your Honor. I think we have a trial scheduled for December currently. There was recently a plea offer that was made, that's under consideration by Mr. Goebel. But additionally, Mr. Goebel, last time I talked to him, had indicated that he was interested in getting a polygraph done, which I think he has a statutory right to. So we would just need to arrange that if he still chooses that he wants to go that route after I talk to him again. So if we could just have an adjournment for another pretrial in, late September, early October, somewhere in that range, maybe that would make sense. So we can get those issues dealt with.
Okay, Ms. McClure, is there anything we need to address from the people's side today?
No, Your Honor, I would concur with Mr. Fry, and I would just indicate for the record purposes that I did let Mr. Fry know to contact Detective Putnam, and he can arrange for that polygraph through the Michigan State Police, including transport of his client, obviously.
Okay, how about October 1st at 8:15?
That would
Okay, and Mr. Fry, would you do the stipulation order for that adjournment of pretrial?
Yes, I can prepare that, Your Honor. Ms. McClure, could I sign your name with permission?
Yes, you may.
Thank you.
All right, Mr. Goebel, then you're all set for today. You can let the officer with you know that you're done with court.
And Judge, I apologize. I'm trying to do a couple different things. Was that date October 3rd?
It was October 1st, I think.
October 1st. Sorry about that.
Could you call jail for James Dodson?
Thank you. Yes. Thank you.
Okay, I've just forwarded all the informations in the plea form on the Torres case.
Okay, thank you.
Sorry, it takes a little bit to do those.
Okay, Mr. Ramos Ruiz, your case is before Judge Anzalone, so you need to log out of this courtroom and log into Judge Anzalone's court. Sir Ramos Ruiz, can you hear me?
Yes.
Your case is in Judge Angelone's court, so you're logged into the wrong court. You need to leave this meeting and log into Judge Angelone's courtroom.
Okay. How do you get that number? How do you get that number, sir?
That number is 993.
Hold on. Yeah, hold on. Where am I doing the phone? Okay. 993. 993.
558.
Okay.
3219.
Thank you so much, Judge. Thank you so much, Judge. George.
You're all set.
Thank you.
Okay, I have the documents we need for Mr. Torres.
And I wasn't sure if I should remove the habitual fourth off of that. So I left it on and added the second. So the fourth can just be dismissed on the nully process sentencing.
Okay.
I thought that was the cleaner way to do it.
All right, Mr. Torres, would you raise your right hand, please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes.
And you are Randy Torres, correct?
Sir.
Mr. Torres, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention in file 25-22298-FH to plead to count 2, attempted unlawful driving away of a motor vehicle?
Yes, sir.
Do you understand that the maximum possible penalty for that offense is up to 2.5 years in prison?
Yes.
You also understand that it requires the Secretary of State to suspend your driver's license?
Yes, sir.
Is it also your intention to plead guilty and file 25-22299-FH to count 1, third degree fleeing a police officer?
Yes, sir.
And you understand the maximum possible penalty for that offense with the habitual offender would be up to 7.5 years in prison?
Yes, sir.
And you understand that that also requires the Secretary of State to suspend your driver's license?
Yes, sir.
So your intention to plead guilty to count 2, operating while intoxicated?
Yes, sir.
And you understand the maximum possible penalty for that offense would be 93 days in jail and or a fine of $100 to $500 and or 360 hours of community service?
Yes.
Are you satisfied with Mr. Glazer and the advice that he's given you?
Yes, sir.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. McClure?
That's correct.
Mr. Glazer?
That's correct, Your Honor.
Is that also your understanding, Mr. Torres?
Yes, sir.
If a guilty plea is accepted, Mr. Torres, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Torres, that if your pleas are accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial. Do you understand that, Mr. Torres?
Yes.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of your rights?
No, sir.
Do you understand that you're giving those rights up?
Yes.
How do you wish to plead in file 25-22298-FH to the charge that on or about June 10, 2025, in the city of Hudson, Lenawee County, Michigan, that you did commit the offense of attempted unlawful driving away of a motor vehicle?
Dustin.
And how do you plead in file 25-22299-FH that on or about June 10, 2000, in the city of Hudson, county of Lenawee, state of Michigan, that you did commit the offense of third degree fleeing a police officer?
Yeah. Guilty.
Sorry, I was not able. Yeah, sorry, one more time.
Guilty.
Okay, and how do you plead in that same file on the same date and location that you did commit the offense of operating while intoxicated?
Guilty.
Has anybody made any threats or promises to you to induce you to plead guilty to those charges?
No, sir.
Do you understand that if I accept your plea, you're giving up any and all claims that your pleas were given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter those pleas?
Yes.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Torres to plead guilty?
None, Your Honor.
No, Your Honor.
Mr. Torres, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
If your plea is accepted and you engage in misconduct, the court is not bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating the terms of a plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes.
Is it your own choice to plead guilty today?
Yes.
Mr. Glazer, do you want to establish the factual basis?
Yes. Mr. Torres, on June 10th, 2025, you were here in Lenawee County in the state of Michigan. Is that correct? Yes. And on that day, you took your mother's car without her permission. Is that true? Yes. And your mother's Mary Lou Torres? Correct. All right. And you, like I said, you didn't have any permission or authority to take that car at the time. Was that correct? Correct. Did you say correct? I couldn't hear you. Yes. All right. On that same date, just about the same time, the police got behind you and were trying to pull you over. Is that true? Yes. And you sped up and tried to get away from the police. Is that correct? Yes. And they had on their flashers and their siren, and they were in uniform. You knew they were police that were trying to pull you over. Is that right? Yes. And you continued to drive in an attempt to flee and elude being arrested. Is that true? Yes. That was also here in Lenawee County, state of Michigan. Is that correct?
Yes.
And it's also true that at that same time you were intoxicated from drinking alcohol that materially and substantially affected your ability to operate the motor vehicle. Is that true?
Yes.
And you do have a prior felony offense, correct? At least one prior felony conviction. Is that correct?
Yes.
Judge, I don't know which one they used, but he admits that he actually has three, I think, but he admits that he knows that there's being one of those used for habitual purposes on that file.
May I have voir dire?
Yeah, that's
Go ahead.
I don't know what date you used.
No, that's okay. For the fleeing and eluding third degree, it requires that the fleeing resulted in a collision or an accident. So, Mr. Torres, do you agree that the only reason you stopped was because you skidded off the roadway and struck some trees, and came to arrest, and that would count as an accident?
Yes.
Okay. And do you agree you were driving in speeds excess of 100 miles per hour on Meridian Highway in the city of Hudson?
Yes.
And when you were driving while intoxicated, do you agree that your BAC was at least a 0.09?
Yes.
And for the habitual offender, do you agree that you were previously convicted on October 31st, 2024 of an attempted controlled substance possession of meth?
Yes.
And that was here in the Lenawee County Circuit Court?
Yes.
Okay. People are satisfied with the factual basis on both charges, or both cases, excuse me.
Has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
Mr. Glazier?
Yes, Your Honor.
Okay, I'll accept the pleas. They've been given understandably, voluntarily, and accurately. Mr. Torres has had full knowledge of his rights and has had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for pre-sentence investigation and set sentencing for September 26th at 8:15 a.m. Mr. Torres, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about your background. Okay. Anything else we need to address with these cases today?
Your Honor, are there fingerprints on both files from Mr. Torres? I know sometimes with those smaller agencies, we don't get them.
Yes, we do have fingerprint information for both files.
Perfect, thank you.
Okay, Mr. Torres, you can let the officer with you know that you are done with court for today.
Oh, one other thing, Your Honor. Does Mr. Torres wish to appear in person from the jail or via Zoom from the jail for his sentencing?
Mr. Torres, you have a right to be present in person for the sentencing hearing if you want to be. I also don't mind if you'd rather do it by Zoom, you can do it that way too, but you'd have to waive your right to be here in person. Do you know right now what you'd like to do?
It don't matter. It don't matter.
Okay. We'll have Mr. Torres brought over in person for that sentencing hearing.
Okay, and that date?
That was September 26th.
Thank you.
Okay, Mr. Torres, you can let the officer with you know that you're done with court for today. Mr. Glazier, do you need to speak to Mr. Dodson?
I need to speak with the prosecutor that's handling that first.
That's my case, Your Honor.
Wait 1 second. Mr. Colwell here?
Yeah.
Okay. Mr. Dagger Margosian, I have Mr. Colwell here in the courtroom. Do you need to speak to him?
I will need to speak with him, Your Honor.
Okay, so Mr. Colwell, if you'll step outside the door of the courtroom, there's an iPad.
Okay.
And I'll put you in a breakout session with Mr. Dagger Margosian.
Thank you, Your Honor.
Thank you.
I imagine she's heavily sedated if they cut off her leg.
Send that request.
Okay, I just did, but I'll do it once more.
I apologize.
Yeah, no problem. Okay, and then you'll need to unmute also. Sorry, Mr. Colwell, I clicked the wrong button. Give me 1 minute to get that corrected.
Okay. All right.
I'm gonna hit join.
Yes. Okay, Mr. Malero, I think I have Miss McCarly here in the courtroom. Are you going to need to speak to her?
Yeah, I would, Judge. That's okay.
Okay, when the iPad becomes available, we will do that. You call for Abel Mendoza, Jim. Mr. Glazier, do you need to speak to Mr. Dodson now?
Yes, I do, Your Honor.
Thank you.
Mr. Monrez, were you able to contact Mr. Merritt or?
I was, Your Honor. I can update the court. Just didn't want to interrupt the docket.
Okay.
Want to call the case you want me to approach? It's easiest for you, Judge.
What's happening with it?
I called Mr. Merritt. Mr. Merritt is out of town on work, which I had forgotten. I called Mr. Coast yesterday. I called chamber staff yesterday, and I called Mr. Sneed to let them know that it was an in-person appearance, but that he wouldn't be able to appear in person. I was told it's better to have him appear via Zoom than not at all. I spoke to him. He said he could hear the court proceedings after we stopped speaking with him, basically. So I think the issue is fixed. Respectfully ask if we can try him again.
Okay.
Thank you, sir.
Mr. Merritt, can you hear me? Mr. Merritt, if you are there and can hear me, I need you to unmute your device. I'm sending you a request to do that.
Okay.
All right, so this is file 25-22173-FH, People State of Michigan versus Brian Merritt. We are here today for a hearing on an order to show cause in this case. And also a pretrial. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. McClure.
CB McClure on behalf of the people, filling in for prosecutor of record Isaac Sneed.
Good morning, Mr. McClure. Nicholas Monterez on behalf of Mr. Brian Merritt, who's present via Zoom and can hear us now, Your Honor.
Okay, and sir, you are Brian Lee Merritt?
Yes.
Mr. Merritt, have you received a copy of the motion affidavit in order to show cause?
I did.
That document alleges that you violated the conditions of your probation by consuming alcohol on July 28th at 6:10 p.m. And that would be, if it were proven, a violation of your bond conditions. The maximum possible penalty for that is up to 93 days in jail or $7,500 in fines. Mr. Monterez, do you know how Mr. Merritt wants to proceed with respect to that alleged contempt?
Yes, Your Honor, we're going to be pleading not guilty again, and I'll notify the court. I spoke with Mr. Coast yesterday as well as Mr. Sneed to inform them that that would be the case. I also sent them a hair follicle and a PETH test result, which both came back negative for alcohol. I was attempting to have the violation dismissed before today, but I was notified that we need to set it for a hearing, so that's what I'd be asking.
Okay. Ms. Clark, we'll need a 1-hour hearing for Mr. Merritt on violation of bond condition.
September 16th at 1:30.
At what time? I'm sorry.
1:30.
So I'm not sure if the trial's going, but Mr. Sneed is in a trial on that day. And I actually am as well in the other courtroom, otherwise I would fill in.
Your Honor, I have a motion to set aside set in the 14A1 District Court at 1 p.m. that afternoon, so we can move that earlier or later, either way, it's fine with me.
Let's find a different date then.
Thursday, September 25th at 1:30 or 2:30.
Either time is fine with me. I'm available.
That works for the people.
With 9:25 at 1:30 p.m. Okay, where are we with respect to the underlying case?
Ms. McClure, I know that you're filling in any issue with me giving the information to the court.
No, go for it.
Okay, I've had conversations with Mr. Sneed. He did review my deviation after returning from vacation. He did make a plea offer in this case. I've discussed it with my client. My client needs to speak with his union rep to determine whether or not this offer would result in him losing his job. So I was going to ask for a 2-week adjournment, Your Honor. But if it makes more sense to set it on the same day as the bond violation on that date, myself and my client will be prepared to either enter a plea or set this matter for trial.
Okay. Why don't we set them for pretrial on the same 9:25 date at 1:30 and just handle everything else?
Understood, Your Honor.
Anything else we need to address today?
Not from defense, Your Honor.
Your Honor, can we just include that pretrial notice on the violation hearing notice in lieu of a stip and order?
That'd be fine, yeah.
Okay. Nothing else on behalf of the people.
And Phoebe, I'll get you guys a packet for the contempt.
Okay, you can provide that to Mr. Sneed, and if I have to cover, he'll get
Very
that to
good.
me.
Okay.
Okay, thank you.
Thank you, Your Honor. Have a nice day.
Mr. Merritt, you can go ahead and log out.
Have a nice day, Your Honor.
Thank you, you too. Okay, Mr. Dagger Margosian, are you ready to proceed with Mr. Colwell?
Your Honor, if I could call Ms. McClure, I have updates on my end of things, and it may lead to resolution. I don't know, but if I could just call her briefly.
Okay. All right, and let's see, Ms. McCarly, if you want to step outside to the iPad, I will set you up with a breakout session with Mr. Malero.
Okay.
Mr. Glazer, I apologize. I clicked the end breakouts, forgetting that you were
That's
still
all
in
right.
there.
I
Dodson, are
was
you-
done. I was done, Your Honor.
Okay. Okay, so this is file 25-22227-FH People versus James Alfred Dodson. We are here today for a pretrial conference, and we are proceeding today by video conference. First, going to have the attorneys place their appearance on the record. We have a prosecutor on, Mr. Dodson.
Sorry, Your Honor. Alex Bayanetto for the people. Sorry, did that come through, Your Honor? Alex Bayanetto for the people.
Mr. Glazer, you want to place your appearance on the record?
Oh, John Glazer on behalf of Mr. Dodson, Your Honor.
Okay, and where do we stand with Mr. Dodson's case today?
Your Honor, we'd asked to adjourn this for a pretrial about 4 weeks away, 6 weeks away. He has a file downstairs that I intend on waiving, and that'll be up to circuit court either next Wednesday or the Wednesday after that. I'm not sure which. He thinks he's going to bond out, and he wants to come in and talk to me about these cases.
I'm sorry, what day was his exam?
It's today. It's a PC, but I've talked to him and I intend on waiving it. So it'll come up for circuit court arraignment probably in a couple Wednesdays. But if I have a pretrial, I'll probably file a waiver of arraignment, just ask it to be set for a pretrial with this case.
All right, so this case is 133 days old. I'll do that, but I would be setting this for trial at that pretrial when we have it.
Yeah, absolutely. We don't have
Just gotta
time.
get on, gotta get moving. Let's go with October 8th at 8:15. And Mr. Glazer, would you do that stipulation in order?
Yes, Your Honor.
Okay, so Mr. Dodson, you're all set for today then.
Thank you, Your Honor.
Mr. Sorry. Mr. Murphy, do you need to speak to Mr. Mendoza? Murphy's calling.
Sorry, Judge.
Okay, Ms. Irwin, have you spoken to Mr. Broughton and are you ready to proceed with him?
I'm ready.
Okay, can we bring Mr. Broughton? Yes. The attorney. This is file 25-22202-FH, People versus Cameron Joseph Broton. We are here today for a pretrial conference. We are proceeding today by proceeding in person, partially in person and partially by video conference. First, can I have the attorneys place their appearances on the record, beginning with Ms. McClure.
E.B. McClure, on behalf of the people.
Ron Dunwood on behalf of Mr. Broton, Your Honor.
And where do we stand with Mr. Broughton's case?
Your Honor, I've had discussions with Mr. Sneed and Mr. Broton. And based on those discussions, Your Honor, Mr. Broton has a sentencing in Saginaw on 9/22. And based on that sentencing, the offer from Mr. Sneed may change at that point, Your Honor. So we would ask for a pretrial on the next available date after 9/22. And I would be happy to do this, stick to adjourn with Ms. McClure's permission.
All right, Ms. McClure, is there anything that we need to address from the people's side?
I do understand that this is Mr. Sneed's case, but I know last time we were here, we were bringing Mr. Broughton in person today in order for him to enter the plea today because he couldn't sign the plea documents otherwise. So, but no issue, I guess, with adjourning it. I just don't know that that offer is going to change. And will we have to bring him back in person again?
I believe we have time, Your Honor, to both get a plea agreement and an advice of rights if the court does not want to do another in-person writ. Mr. Broughton, do you wish to be here in person?
Yes, I do.
Okay, then hopefully that will be.
Okay.
I'm pretty sure there's going to be a plea at that point, Your Honor.
So what I'll do is set this for October 1st at 8:15.
Thank you.
And Mr. Broughton has requested to be in person, so we'll ask for an in-person writ on that.
Thank you.
Thank you, Your Honor.
Yeah. Ms. Underwood, if you'll do that stipulation in order, please. Okay, is there anything else we need to address?
Nothing else, Your Honor.
Okay, thank you, then you're all set. Okay, Mr. Dagger Margosian, are you ready? Oh, I'm sorry.
We're
Are you
ready.
yet?
Yes, thank you.
Okay. Mr. Cowwell, you can come forward, please. All right, this is file 25-22125-FH, People versus Christopher Joseph Cowwell. We are here today for a pretrial conference in this case, and we are proceeding today partially in person, partially by Zoom. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure.
E.B. McClure on behalf of the people. And apologies, Judge, my video won't turn on. I'm getting an error from Zoom, so I apologize.
Your Honor, Michael Dagger Margosian for Mr. Cowwell.
Okay, Mr. Dagger Margosian, where do we stand with Mr. Cowwell's case?
Your Honor, we are in the process of getting some documents that would assist in resolving this case. We don't have those currently, but we are working on that. If we could adjourn the pretrial for a few weeks, I think we would be able to get this done.
Okay, Ms. McClure, is there anything we need to address from the people's side?
No, nothing on behalf of the people.
So let's set it then for September 24th at 8:15. And Mr. Dagger Magosian, will you do that stipulation in order, please?
Yes, Your Honor.
Okay, so Mr. Colwell, your next date is September 24th at 8:15 a.m.
Okay, thank you, Your Honor.
Your Honor, can I just address Mr. Cowell for a second?
I'm sorry.
Yes.
Mr. Cowell, does your phone still end in 3310?
Correct.
Okay, I'll give you a call. Thank you.
Thank you.
Okay, Mr. Malero, are you ready to proceed with Ms. McCarly?
Yes, I am, Your Honor.
Is file 25-22378 versus Dawn Marie McCarly. We are here today for an arraignment. In this case, we're proceeding today partially by video conference and partially in person. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure?
Phoebe McClure, on behalf of the people.
Salvatore Malero on behalf of Dawn McCarly.
And Miss, you are Dawn Marie McCarly?
I am.
Okay. Mr. Malero, does Ms. McCarly wish to have the information read?
Your Honor, at this time, we would waive the reading of the information, waive any defects as time and place of service. We would plead not guilty to counts 1 through 6 in the habitual offender 4th offense notice. We would also acknowledge receipt of the witness list and ask that the matter be set for pretrial.
All right, under not guilty plea for Ms. McCarly set for a pretrial on October 8th at 8:15 a.m.
I'm sorry, Judge, what was that date?
October 8th.
10/8. Okay, great. Thank you, Judge.
Okay, so Ms. McCarly, you are all set for today. Your next date is October 8th at 8:15.
Thank you, Judge.
Okay. Mr. Blair, you need to speak to Mr. Harris.
Not unless he wants to.
Okay, Mr. Harris, can you hear me?
Yes, sir.
Do you need to speak to Mr. Malero before we start?
Yes.
Okay, 1 second. I'll put you in a breakout room with him.
Okay, thank you.
Rồi, phải mà ba ngày nào đấy còn món cháo.
Thank you, Judge.
Mr. Mendoza, I apologize. Mr. Murphy was here and then he left while they were in the process of bringing you. So as soon as Mr. Murphy gets back, I'll have you talk to him. We'll get going on your case.
Okay, Your Honor, thank you.
Your Honor, is Mr. Dunning, is there a Dwayne Dunning in the courtroom?
Yes, there is.
Could we call his case real quick?
Mr. Dunning, you want to come forward? All right, this is file 25-22172-FH People versus Dwayne John Dunning. We are here today for a pretrial conference in this case, and we are proceeding today partially by video conference and partially in person. First, going to have the attorneys place their appearance on the record, beginning with Ms. McClure.
Phoebe McClure on behalf of the people.
Salvatore Malero on behalf of Dwayne Dunning.
And sir, you are Dwayne John Dunning? Yes, sir. Okay, Mr. Malero, where do we stand with Mr. Dunning's case today?
So Judge, I believe Mrs. McClure has submitted a nollie prosequi to the court. If the court has that and the court intends to sign it, I would ask that that be taken care of, so Mr. Dunning doesn't have to sit around too much longer.
And Your Honor, I just wanted to place something on record regarding that dismissal.
Go ahead.
I just wanted to indicate for the record that our office did attempt to reach out recently to both Teresa and Christine. While up until just this last month or so, they had been in pretty steady contact with us regarding this case. They recently have been less in contact with us. We actually got a pretty nasty message from Christine. They've not indicated to me that they've had any contact about the case from Mr. Dunning. That being said, this dismissal, as far as I know, would be without prejudice. So if there are any issues in the future between Mr. Dunning and Teresa or Christine, that we would consider this case as well, if there was another case that had to be filed, and consider this case for potential reissue. So I guess I would just impress upon Mr. Dunning to, not to have any assaultive contact or attempt to have any issues with Teresa and Christine.
And Judge, just to supplement that, Christine's the daughter. I believe it's Christine.
I
And
think Teresa's his daughter and Christina is
oh.
his ex-wife.
all right. Well, yeah, the mom and the daughter did contact our investigator and had indicated they no longer wanted to pursue the matter. But Mr. Dunning understands what Mrs. McClure is saying. And if he needs further clarification, I'd be happy to explain it to him if he comes to the office.
Okay, so I have been handed that order, and I have signed that, so we're all set.
All right. So, Mr. Dunning, if you come to the office, we can give you a copy of the order, or we can mail it to you.
Yeah, you can just mail it, it's fine, I'm good.
Okay. Judge, there's no contempts pending or anything like that?
No, we don't have anything else.
Okay, great. Thank you, sir. Thank you, Your Honor.
Okay,
Thank you, Your Honor.
you're all set.
Have a good day. Thanks, Sam.
And thank you, Ms. McClure.
Okay, Mr. Miller, are you ready to proceed with Mr. Harris then?
Yes, Judge, I am.
Okay, so this is file 25-22314-FH and 25-22371-FH. People versus Dwan Pfeiffer Harris. We are here today for pretrial conferences in both of those cases. I'm sorry, we're here for arraignment in both of those cases, and we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Mr. Hartung.
Thank you, Your Honor. Doug Hartung, appearing for the people.
Salvatore Malero on behalf of Mr. Harris.
And sir, you are Dwan Pfeiffer Harris?
Yes, sir.
All right, Mr. Malero, does Mr. Harris wish to have the information read?
Your Honor, at this time, we would acknowledge receipt of the information on the 371 FH file. We'd waive its reading in open court. We'd waive any defects as to time and place of service. Mr. Harris would plead not guilty to both counts 1 and 2. I do not see a habitual offender notice. And we'd also acknowledge receipt of the witness list. And we'd ask that a pretrial be set. And for the other matter, we'd ask that that be set for additional pretrial with this case. And then we'd like to address the bond conditions, Judge.
All right, so enter not guilty plea for Mr. Harris in both cases. Is that a pretrial for October 8th at 8:15? And what is it you'd like to address about the bond?
Judge, we've had preliminary exams for both of these cases where, I have to order the transcripts. At the one that we just arraigned them on, though, I think it's become clear that for some reason the police authority has some kind of problem with Mr. Harris being out on bond. There was a request that with respect to Mr. Harris, we had a little exchange about him having contact with the witness who was in the car with Mr. Harris at the time of the alleged offense. There was no order that he not have contact with this person. From my point of view, there was no indication that he threatened the person. He spoke to her at the courthouse and he sent a text message to her spouse or boyfriend. And so we don't have a problem with there being a no contact order. However, the court ordered a GPS tether on Mr. Harris. He's appeared in court. He has always conducted himself appropriately in my presence and in the court's presence. That I don't have any recollection that he hasn't. And so that is an expense, Judge, and just for the court's edification, the first case, we did a preliminary exam. and they immediately arrested him upon him walking out of that courtroom on this charge we're here now. And so clearly these officers have some kind of animus with respect to Mr. Harris. They don't like him. It's obvious they don't like him being out, and they're trying to make his life as difficult as possible. And they're imposing these burdens on him in an effort to punish him when he has, there's the allegations, but with respect to this particular issue, didn't file any charges that he's witness intimidation. I don't believe the witness testified at the prelim. She didn't seem scared to me about anything. So I'd ask the court to remove the tether requirement, but we have no objection to there being a no contact order. Mr. Harris understands the ramifications of such a thing and would follow that court order. That's our request, Judge, as respect to the bond conditions.
Mr. Hartung?
Thank you, Your Honor. First of all, I do believe, backing up just a bit, both informations do show habitual offenders supplements, drug supplements on these cases, Mr. Lyle. Just if you haven't received that, let me know, and I'll make sure you get the one that has it on it. But that was the intention that filed in both cases here.
Well, that's why I brought it up, because I do not see it.
Okay, we'll make sure that you get the one that has both of it on it. Your Honor, at the time of the preliminary examination on the case that is the newest case before Your Honor, I very clearly recall the witness testifying at that time that she had run into Mr. Harris at the same courthouse the day before and said that he was very, using her words, very aggressive towards her. And she did feel a little intimidated by what happened. He also sent a text message, testimony came in, he sent a text message to the witness's fiance, basically asking her to take responsibility for the drugs in that particular case. So I disagree with the assertions there by Mr. Malaro that she did not feel at all threatened or at least intimidated to some degree based on his aggressive attitude towards her. Secondly, I think it's probably fair to say the animus here from the Rhino unit was against anyone who commits a crime. And in this particular case, I advised Mr. Malaro at the end of the first preliminary examination that they did intend to arrest him after the conclusion of that hearing. So they knew that was going to happen. And Mr. Harris was very cooperative with them, as he has been in all his court hearings. He's always shown up for every single court hearing on time, occasionally early. But Judge Shadler, having heard all this testimony, and not at my request, nor in opposition to anything that Mr. Malaro had set up at that point in time, decided to order the tether. And I fully support her decision to order the tether. I think it's appropriate. We can always review it at a later point in time down the road here. But the Rhino unit had maintained a position that they were very concerned that Mr. Harris was going to leave the jurisdiction. Now, he's showed up for every single court hearing. I put that on the record last time we had a bond discussion as well. But he does have a history in district court of not showing up for court hearings. And that was placed on the record as well at that time. So I think we can leave it where it is for now and review it again on October 8th. See how things are going at that point in time.
Well, Judge, to respond to that, if I recall, I think first of all,
okay. So Mr. Malaro, I'm gonna interrupt because we're having a debate about a factual dispute about what was heard and said and happened at a hearing that I wasn't at, and I'm not going to rely on people's memories in order to make a decision to modify bond when there are those kinds of disputes happening. If you'd like to get the transcript and or schedule a hearing and present evidence for me to review and consider, I'm happy to do that. But to try to make a decision based on you and Mr. Hartung going back and forth about what happened, I'm just not going to do that.
All right, Judge, we'll do that.
All right. Is there anything else we need to address with the case today?
No, Your Honor, thank you.
No, thank you.
Okay, Mr. Harris, you can go ahead and log out then.
Okay, sir.
Mr. Gargan, you want to come forward, please? Take this. Okay. All right, this is file 24-21979-FH People of the State of Michigan versus Paul Anthony Gargan Jr. We're here today for an arraignment on an alleged probation violation. We are proceeding today in person. Sir, you are Paul Anthony Gargan Jr.?
Yes, Your Honor.
Mr. Gargan, have you received a copy of the request and summons for probation violation?
Yes, sir.
That alleges that you have failed to comply with the terms of your probation by not making payments toward your restitution, fines, and costs since the sentencing back in April 2025, and that there's a balance owing of $22,415.16. Do you understand that?
Yes, sir.
You had previously in this case pled guilty to embezzlement by an agent or trustee, of $200, of at least $200, but less than $1,000. Do you understand that the maximum possible punishment for that offense is 1 year in jail and or a $2,000 fine of 3 times the amount embezzled?
Yes, sir.
You do have the right to be represented by an attorney here today and at any other hearings we have regarding this matter. If you can't afford an attorney, you can tell me that and I'll appoint one for you from the public defender's office. Do you understand that?
Yes, sir.
Would you like to be represented by an attorney today?
I don't have one right now.
Well, do you want to be represented?
Yes.
Do you have the ability to pay for your own attorney?
It'll take me a couple of days to get some money around, but yes.
All right, so what I'll do is enter a not guilty plea for you for now. And I'll set this for a hearing on September 24th at 8:15 a.m.
Your Honor, can that be through Zoom? I work night shift and right now I'm been up for 24 hours. I have to drive an hour.
You can attend that by Zoom, yes.
Thank you, sir.
And so have your attorney here for that as well. You'll get a notice in the mail. Make sure you get a copy of that to your attorney.
Yes, sir.
Right, so you're all set for today.
Thank you.
You need this.
What is that?
Sarah, how to get to
Oh, all right. Thank you.
Okay, let's see, Mr. Decker, if you want to step outside to the iPad, I'll put you in a breakout session with Ms. Underwood from the Public Defender's
Your Honor,
Office.
I'm right down the hall. I can come out in the hall.
Okay, so just step out in the hallway, she'll be out. And let's see, Mr. Murphy, do you need to speak to Mr. Mendoza?
Okay, please, Your Honor.
Can we get Kareem Henry from the judge, please? Thank you. Bye.
Rhonda, he's out in the hallway.
Okay, thank you. I'm reviewing the documents. I'm sorry, Your Honor.
Oh, okay. You take this and give it to Sierra. Okay, we do Mr. Decker. We are back on the record in file 25-52369-PP. Roland Ray Perro versus Elijah Bradley Decker. And we have Ms. Underwood here now who has spoken to Mr. Decker. Ms. Underwood, you want to place your appearance on the record?
Rhonda Underwood for Mr. Decker this morning, Your Honor.
Okay. And do you know how Mr. Decker wishes to proceed today?
Absolutely, Your Honor. Mr. Decker wishes to enter a not guilty plea in this matter, Your Honor. He has been advised, of course, that no contact is doubly in place and he is not to be anywhere near this person. And we would ask for what date, Your Honor?
Okay, let's see, Ms. Clark, could you give us a 1 hour hearing date for a PPO violation?
Yes, Tuesday, September 30th at 1:30.
Your Honor, that date sticks in my mind for a reason. I don't think I'm available.
Okay. Could we have another date, Ms. Clark?
Wednesday, October 1st at 3:30.
That's better. Thank you, Your Honor.
October 1st, I'm sorry, was that 3:30?
Yes.
Okay. All right, so October 1st at 3:30 p.m. Ms. McClure, are you there?
Yes.
To my knowledge, the petitioner does not have his own representation. Are the people available at that time?
And that was October 1st at what time?
At 3:30 p.m.
You're not, Your Honor, I know the documents were prepared by an attorney's office.
Oh, I'm sorry. They were. I apologize, Ms. McClure. Looks like petitioner does have a private attorney, so we will notify Mr. Miller.
Okay, sounds good.
Okay, so the court will send out a notice.
Thank you, Your Honor.
Thank you. You call her name. All right, Mr. Murphy, are you ready to proceed with Mr. Mendoza?
Yes, Your Honor.
We are on the record in files 25-22323-FH, 25-22324-FH, and 25-22325-FH. People versus Abel Mendoza. We are here today for a pretrial conference in each of those cases. There's also a pending contempt of court from, I believe, failure to appear while this was in district court in 2 of the 3 files. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure?
B.B. McClure on behalf of the people.
Matthew Murphy, appearing on behalf of Mr. Mendoza.
And Mr. Murphy, where do we stand with Mr. Mendoza's case today?
Your Honor, at this time, the offer from the people will be for Mr. Mendoza to plead in file 323 FH to an added count of attempted possession of a dangerous weapon, i.e. a blackjack, and in file 2522324 FH to plead as charged to the failure to comply with the Sex Offender Registry Act. The habitual offender statuses will be dismissed in both of the files, as well as the remaining file. I don't have the number right in front of me. What file is that? 2522325 FH. Mr. Mendoza does wish to accept that offer and again plead guilty to an attempted possession of a dangerous weapon in file 2522323 FH and as charged to failure to comply with the Sex Offender Registry Act in 2522324 FH.
Okay,
There
Ms.
is a-
McClure, is that it? Oh, I'm sorry.
I do have a plea offer was sent over. I'm currently at the courthouse right now, so I can't really print it and sign it. I'll have that printed and signed right when I get back to the office, to the court.
And the court should have a copy of that unsigned, that I sent with the amended information, and that is an accurate recitation of the plea.
Okay, and we will have an advice of rights form taken over to Mr. Mendoza right now at the jail.
Thank you, Your Honor.
Okay, Mr. Mendoza, would you raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do.
And you are Abel Mendoza?
Yes, Your Honor.
Mr. Mendoza, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty in file 25-22323-FH to attempted possession of a dangerous weapon?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is 2.5 years in prison or a $2,500 fine?
Yes, Your Honor.
Do you understand it also requires mandatory forfeiture of the weapon?
Yes, Your Honor. Yes, I do.
Is it also your intention in file 25-22324-FH to plead guilty to count 1, failure to comply with reporting duties of a sex offender?
Yes, Your Honor.
You understand that the maximum possible penalty for that offense is up to 2 years in prison and or a $2,000 fine?
Yes, Your Honor.
Are you satisfied with Mr. Murphy and the advice that he's given you?
Yes, I am, sir.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. McClure?
That's correct.
Mr. Murphy?
That's correct, Your Honor.
Is that also your understanding, Mr. Mendoza?
Yes, Your Honor.
If guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial, and explain those rights to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify if you wanted to testify. Do you understand, Mr. Mendoza, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, Your Honor.
That's correct.
Okay, thank you.
Do you also understand that any appeal from the conviction and sentence pursuant to the plea would be by application for leave to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
The citizenship? What's that mean? No.
So if you are not a U.S. citizen?
Oh, no. Yeah. Okay. I thought you're. No, I'm good.
Okay. Do you have any other questions about any of your rights?
No, Your Honor.
Do you understand that you're giving them up?
Yes, sir.
Okay, did the officer hand you an advice of rights form?
Yes, I have it right here.
Okay, can you read through that? Take whatever time you need. Let me know when you're done. And did they give you a pen to sign it?
No, they did not.
Okay. Keep on that. We will have them bring you a pen in just a moment. And so take your time, read through it. And if you're comfortable, just let me know, and then we'll have you sign it once you get a pen.
Okay. All right. Thank you.
Thank you for taking Mr. Mendoza the advice of rights. He does not have a pen to sign. All right, thank you. Bye.
Mr. Malero, while we're waiting, are you going to need a breakout session with Mr. Henry?
Yeah, I do, Judge.
Sir Henry, I'm going to send you a request to unmute that device. Just click yes or whatever it asks you to do.
Yes, Your Honor.
Okay. And I'm going to put you in a breakout session with Mr. Malero.
Thank you, Judge.
I'm done, Your Honor. I just need a pen.
Okay, they should be bringing that to you. So we can continue. Just if you're ready to sign it when they bring you that pen, just sign it.
Yeah.
All right, so in file 25-22323-FH, Mr. Mendoza, how do you plead to the charge that on or about February 13, 2025, in the city of Adrian, County of Lenawee, that you did commit the offense of attempted possession of a dangerous weapon?
Guilty, Your Honor.
And in file 25-22324-FH, how do you plead to the charge that on or about February 11, 2025, in the city of Adrian, County of Lenawee, state of Michigan, that you did commit the offense of failing to comply with reporting duties for a sex offender?
Guilty, Your Honor.
Has anybody made any threats or promises to you to induce you to plead guilty to those charges?
No, Your Honor.
Do you understand that if I accept those pleas, you'll be giving up any and all claims that those pleas were given as a result of threats or promises that were not disclosed to the board on the record this morning, or that it was not your own choice to enter those pleas?
No, I do, Your Honor. I do.
I'm sorry, do you understand that?
Yes, yes, I do.
Okay. Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Mendoza to plead guilty today?
None, Your Honor.
I just told Mr. Mendoza I'd ask to address bond after the plea. That was all.
Okay. Mr. Mendoza, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, he didn't promise me, but as he said, it was like a 2-year max. So
okay. So you had some discussions with him about what the sentence could be, but he did not make any promises. Is that correct?
No. Yeah, that's correct. Okay. That's correct.
You understand ultimately that that's my decision that I
have
to figure out.
Yeah, I told him. Yes, okay. I told him.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes but is not limited to absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, Your Honor.
Is it your own choice to plead guilty today?
Yes, Your Honor.
Mr. Murphy, would you like to establish the factual basis?
Yes, Your Honor. Thank you. Mr. Mendoza, can you hear and understand me?
Yes, yeah.
All right, Mr. Mendoza, were you indeed in the city of Adrian, the county of Lenawee, state of Michigan on February 13th, 2025?
Yes, it was.
Okay, this is in regards to the possession of the weapon. Did you
Yeah.
indeed have in your possession a weapon referred to as a blackjack?
Yes.
Okay. And were you aware that it was in your possession?
Yes, I was.
Your Honor, I think we've satisfied the factual basis for that one. Obviously, he admitted to a greater offense and he's pleading to the attempted. So I think we've satisfied the factual basis for that.
Just one follow-up question on that. Mr. Mendoza, do you agree that a blackjack is or can be considered a dangerous weapon under the statute?
Yes, I do. I do.
Okay, and do you have a CPL or any other license to carry a
No,
concealed? Okay.
No, I don't.
People are satisfied with the factual basis.
All right, moving on to the next file. Mr. Mendoza, again, were you indeed in the city of Adrian, the county of Lenawee, state of Michigan on or about February 11, 2025?
Yes, I was.
And were you aware that you were on the sex offender registry at that time?
Yeah, I knew I was.
Okay, you were aware of your requirements and your duties for that?
Yeah, but I didn't. Yeah, I did, but I was home.
That's all I needed. And
Okay.
you didn't comply with those?
Yeah, I
And,
didn't.
change your address?
Yeah, I should have. I was my fault.
That's all. It's no more.
Yeah.
Yeah, I think we've satisfied the factual basis on that, unless Ms. McCarly.
Satisfied, Your Honor.
Okay. Has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
Mr. Murphy?
It has, Your Honor. Thank you.
All right, I will accept those pleas. Then they have been given understandably, voluntarily, and accurately. Mr. Mendoza has had full knowledge of his rights and he's had competent counsel. The court's not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer the matter to the probation department for a pre-sentence investigation and set sentencing for October 2nd at 8:15 a.m.
Thank you, Your Honor.
And Mr. Murphy, you said that you would like to address bond.
Yes, Your Honor, but was that October 2nd or October 7th?
Second.
All right, thank you, Your Honor. Yes, Your Honor, in regards to the matter, I would ask the court to consider giving Mr. Mendoza a personal recognizance bond. There is obviously the failure to appear on the case. So Mr. Mendoza has been homeless for a bit of time. That explains, or that's one of the reasons why he was not able to register. He didn't really understand how to do that accurately, and as well as failing to appear. But Mr. Mendoza, his mother has been in contact with my office repeatedly over the past weeks. He has indicated, and I think she was indicating, that he could stay at her house. And also, Mr. Mendoza, he does have an intention, I believe, he has family members that own construction companies that will give him employment. He does have, front of the court obligations, child support obligations. He wants to start earning money to make good on those, as well as any fines and costs that will be incurred on this. So I'd ask the court to consider, again, giving him a PR bond, giving him a chance to show the court that he doesn't need to be incarcerated, or the resources don't need to be, diverted to that. I guess you use the phrase, maybe give him enough rope to hang himself with. Obviously, I don't expect him to hang himself, but just, obviously, I believe that moving forward, he has no intention of not appearing at sentencing. He took responsibility for his action in these matters. So I'd ask the court to consider reducing the bond to a PR bond. Thank you.
Ms. McClure, anything from the people on the issue of bond?
Just a few things, Your Honor. I have no objection to a reduction to a PR bond, but given that he is still he's listed as non-compliant on the sex offender registry, I would just ask that he become compliant, or at least verify before the sentencing date. In addition, so upon his release, I would ask that he verify or register his address, or however he does that when you're homeless. And as it relates to his previous contempt for non-appearance, I would just impress upon Mr. Mendoza that by statute, if there is any failure to appear at sentencing, or failure to appear for even the PSI interview, that could jeopardize his plea agreement.
Okay, I will then change the bond to a personal recognizance bond. I will require, Mr. Mendoza, that you report to Darren Coast in Circuit Court Pretrial Services. So when you are released, you'll need to come over to the courthouse up to the 3rd floor, go to the clerk's office and ask for Mr. Coast. He'll come out to the hallway and see you.
Okay, Mr. Coates, Mr. Coates.
Coast, it's K-O-S-T.
Okay, K-O-S-T. Okay. You're on, they still haven't given, am I supposed to still sign this before I go? This paper?
Yeah.
They haven't come with no pencil.
Okay.
I need an address then.
It's 311.
One second. I don't want you to give that right now. I'll put you in a breakout session with Ms. Holly.
Okay.
You can give that to her separately. So additionally, condition of probation is that when you get out, you do your duty under the SORA Act and register, get yourself registered and compliant with the SORA Act.
Yes, Your Honor.
Okay, I will put you in a breakout session with Ms. Holly right now. Mr. Murphy, do you want to be involved in that?
I don't need to be, Your Honor. Thank you.
Okay.
Thank you, Your Honor.
Okay. Call for Brandon Martins.
Brandon. Thank you.
Okay, Mr. Malero, are you ready to proceed with Mr. Henry?
Yes, I am, Judge.
Okay, so this is file 25-22326-FH People versus Kareem Jamal Muhammad Henry. We are here today for a pretrial conference in that case, and we're proceeding today by video conference. First, going to have the attorneys place their appearances on the record, beginning with Ms. McClure.
B.B. McClure on behalf of the people.
Salvatore Malero on behalf of Kareem Henry.
And where are we with Mr. Henry's case today?
Judge, we're going to ask to adjourn the matter one time. I think we should have it resolved by the next court date.
Okay, Ms. McClure, anything to add from the people's side?
No, and no objection.
Okay, let's go with October 1st at 8:15.
Your Honor.
Judge, Mr. Henry would like to address the court regarding an issue with his property at the jail. See if you can help him resolve this matter.
Okay, what is that, Mr. Henry?
Your Honor, I've been here since June 25th. I'm not asking for sympathy, I'm just asking for understanding. I lost my apartment already for being in here. Now my car is stuck in a spot where they can't get it. The jail policy is that they don't give up property unless I'm released or I'm going to prison. That's just the prior property policy they have. I talked to every supervisor that I need to. They just said all I need is a judge order or court order saying that they can release my property to my family.
Who is it that you'd like it released to?
I can release it to Mr. Malero, or I can release it to my mom or my child's mother. Either one. I'm not from here. I'm from Detroit, so it's like an hour and a half away too. So
I just need a name of someone.
You can
do your mother, Mr. Henry.
My mother, okay. Denise Key McCago.
Denise Key, like Key?
Yes, sir. Key. McCago is McCoggle.
Okay. I will contact the jail, and if they will do that upon my order, I'll issue an order.
Thank you, Your Honor.
Okay.
Thank you,
Anything
Judge.
else?
No, Your Honor.
Okay, Mr. Henry, you're all set then for today. You can let them know that you're done with court.
Thank you, Your Honor. Appreciate it.
Call for Sarah.
Your Honor, I'm gonna log out and log back in and see if it corrects the camera issue I've been having.
Also, we do Alan Whiteman.
Hi, it's fun to get into. Could we have Sarah Reed Whiteman, please? Great, thank you so much.
It did not correct my issue. I'll have to get with IT after court.
Okay. I have a device logged in as LCJG917RH. I've sent you a request to turn the video on. Okay, you are Mr. Whiteman?
Mr. Martin.
Mr. Martin, I'm sorry. Ms. Underwood, do you need to speak to Mr. Martin?
Yes, please, Your Honor.
Okay, are you Ms. Reed?
Yes.
All right, your attorney is working with another person right now. As soon as she's available, I'll have you speak to her.
Okay.
Okay, this is file 18-19014-FH, People versus Brandon Matthew Martin. We are here today for hearing on a alleged violation of probation. We're proceeding by video conference. Ms. Underwood, you want to place your appearance on the record?
Ron Underwood for Mr. Martin this morning, Your Honor. Thank you.
And where do we stand with Mr. Martin's case?
I've had some discussion with Mr. Jones and Mr. Martin, and Mr. Martin will be pleading guilty to the violation today, Your Honor. I believe the recommendation is going to be 6 months and jail time and terminate. In addition, Your Honor, I would just state very quickly that Mr. Martin was given a PR bond by this court, and unfortunately, did not know he had a district court matter, Your Honor, where the bond was $5,000, so he was not able to get out. So I would ask that Mr. Martin be given credit for the time he's been serving.
All right, Mr. Martin, would you raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor, I do.
And you are Brandon Matthew Martin, correct?
Yes, sir.
Sir Martin, do you understand that you have the right to contest this violation of probation charge and to have a trial on it?
Yes, sir, I do.
Do you understand that throughout that trial, you'd be presumed innocent until your guilt is proven by a preponderance of evidence?
Yes, sir.
You would have the right to have all the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions while they are under oath. And you also have the right to have me order any witnesses that you have for your defense to appear at your trial. Do you understand all of that?
Yes, sir, I do.
You do not have to testify at your trial, and no one can say anything about you not testifying or hold that against you in any way. Do you understand that?
Yes, sir.
On the other hand, you have the right to testify at your trial if you wanted to testify. Do you understand that as well?
Yes, sir, I do.
How do you plead to the charge that you violated your probation by failing to report on December 6, 2022 or any time thereafter?
Guilty.
Do you understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I've just explained?
Yes, sir.
Has anything been promised to you in order to get you to plead guilty?
No, sir.
Has anybody threatened you in any way in order to get you to plead guilty?
No, sir.
If I accept your plea, you'll be giving up any and all claims that the plea was given as a result of threats or promises disclosed to the board on the record today, or that it was not your own choice to enter the plea. Do you understand that?
Yes, sir.
Is it your own choice to plead guilty today?
Yes, sir, it is.
So you were placed on probation in this case back in looks like August of 2018. Is that correct?
Well, I think it might have been, yes.
Okay. If the file shows that your sentencing date was on August 24 of 2018, would you have any reason to dispute that?
No, there was another case, that was for child support, and there was another one after that.
Okay.
I thought. So I guess it was just a different file.
Okay. One of the terms of your probation was that you report as instructed to your probation officer. Is that correct?
Yes, sir, it was.
And did you fail to report to Mr. Jones on December 6, 2022?
Yes, sir, I did.
And did you report to Mr. Jones at any time between December 6, 2022 and the date that you were arrested on this warrant just a couple of days ago?
No, sir, I did not.
Okay. I will accept the plea that it's been given understandably, voluntarily, and accurately. Mr. Martin has had full knowledge of his rights. He's had competent counsel. I will refer the matter to the probation department for an update of your pre-sentence investigation. And we can set sentencing for September 26th at 8:15 a.m. I would note that Mr. Martin was arrested on this warrant on August 24th of 2025, and so I would give him credit when we get to sentencing. I'll give him credit from that date forward.
I appreciate it, Your Honor. Thank you.
Okay.
I also ask, I'm sorry.
Yeah, no, go ahead, Mr. Jones.
I was just gonna ask, are we gonna leave the PR bond in place on this case, or should we change that? Because I'm gonna recommend some jail.
Yeah, thank you. I'm going to revoke the bond at this time so that he'll get credit for any time served between now and the sentencing.
Okay.
Thank you, Your Honor.
Yeah, thank you, Your Honor.
Okay, and so Mr. Martin, someone from Mr. Jones will be in touch with you to do an updated pre-sentence investigation. When you do the interview with him, please be truthful about what's happening about your background.
All righty, I will.
Okay, so you're all set for today. You can let them know that you're done with court.
All right, thank you, Your Honor.
What date was that for the sentencing, Your Honor? I'm sorry.
27.
September 26th.
26. All right. September 26th.
All right, Ms. Underwood, you need to speak to Ms. Reed.
I don't believe so, Your Honor, if we have all the documents ready.
Okay, so this is file 25-22306-FH People versus Sarah Lynn Reed. We are here today for a pretrial conference. We're proceeding today by video conference. First, can you have the attorneys place their appearances on the record, beginning with Ms. McClure.
B. McClure, on behalf of the people.
Rhonda Underwood on behalf of Ms. Reed, Your Honor.
And where do we stand with Ms. Reed's case today?
Your Honor, the offer from the prosecutor is that Ms. Reed would plead guilty to a misdemeanor retail fraud second count, Your Honor, added count. So that's on the amended. And be released at plea to pay the $250 restitution prior to sentencing, Your Honor, in order to keep that misdemeanor plea. And I believe that Ms. Reed wishes to accept that offer, Your Honor.
Okay, Ms. Reed, would you raise your right hand, please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury. I'm sorry, I was not able to hear you.
Yes, sir.
Okay.
And Your Honor, just to clarify how that plea is worded. So Ms. Underwood is correct as to what the plea offer is. Restitution is $250, and restitution must be paid either before or at the time of sentencing in full, or the felony would be reinstated. So the plea would be withdrawn and the felony would come back into play. I just wanted to clarify that.
All right. Ms. Reed, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 2 retail fraud second degree?
Yes.
Do you understand the maximum possible penalty for that offense up to 1 year in jail and or a fine of $2,000?
Yes, sir.
Are you satisfied with Ms. Underwood and the advice that she's given you?
Yes, sir.
Neither the prosecutor, defense attorney, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we discussed on the record here today. Is that correct, Ms. McClure?
That is correct.
Ms. Underwood?
Correct, Your Honor.
Is that also your understanding, Ms. Reed?
Yes.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to have the prosecuting attorney. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Ms. Reed, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, sir.
Do you understand that any appeal from the conviction and sentence pursuant to this plea would be by application for leave to appeal and not by right?
Yes, sir.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, sir.
How do you wish to plead to the charge that on or about June 19, 2024, in Madison Township, Lenawee County, Michigan, that you did commit the offense of second-degree retail fraud?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No, sir.
Do you understand that if I accept your plea, you'll be giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea?
Yes, sir.
Is prosecutor and defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Ms. Reed to plead guilty?
No, sir.
None, Your Honor.
Ms. Underwood, are you aware of any promises, threats, or inducements other than the plea bargain to induce Ms.
No,
Reed to
Your
plead guilty?
Honor.
Okay. Ms. Reed, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
Has someone brought you an advice of rights form?
Yes, sir.
Have you had a chance to look at that?
Yes, sir.
Okay, if you're comfortable with it, are you willing to sign it?
Yes, sir.
Okay, go ahead and sign it if you've not done that already.
Let me grab a pen.
Okay.
Judge, we received her signed advice of rights this morning because it was sent over yesterday to the jail.
Oh, I'm sorry. So we're all set, Ms. Reed. You don't need to sign that. If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes but is not limited to absconding or failing to appear at sentencing, violating bond conditions, violating terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, sir.
Is it your own choice to plead guilty?
Yes, sir.
Ms. Underwood, do you want to establish the factual basis?
Absolutely, Your Honor. Thank you. Ms. Reed, I take you back to June 19th, 2024. Were you at the Adrian Walmart store located in Madison Township in the county of Lenawee, in the state of Michigan?
Yes, ma'am.
And that is a store that is open for business, correct?
Yes, ma'am.
And at that time, did you walk out with items totaling $250 from the self-scan that you did not pay for?
Yes, ma'am.
And you got away with those items. Those items were not returned, correct?
Correct.
And you had no permission to take those items.
Correct.
I believe the factual basis has been established, Your Honor.
Satisfied, Your Honor.
Has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
It has.
All right, I will accept the plea that's been given understandably, voluntarily, and accurately. Ms. Reed has had full knowledge of her rights. She's had competent counsel. The court's not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation. And we will set sentencing for,
Your Honor, could we have perhaps a little longer for sentencing to allow Ms. Reed to get her feet under her? She's been incarcerated for a while. So I want her to have some time to get that money together.
And I have no
Okay.
objection to that, Your Honor.
all right, how about October 30th at 8:15?
Thank you, Your Honor.
Okay, so Ms. Reed, this, you will need to report to report to Mike McCarron in the District Court Probation Office this coming Tuesday at 8:15 a.m.
Okay,
And as discussed, the court will issue a PR bond at this time.
thank you, sir.
Anything else we need to address today, Ms. Underwood?
No, Your Honor. Thank you.
Okay.
And I guess, I hope it goes without saying, but Miss Reed is not allowed back at Walmart.
Right.
Thank
So
you.
yeah, I don't know if that's in bond conditions already, but if it's not, we'll include that now that you're not to be at the Walmart.
I believe she was given a trespass notice as well.
Yes, sir.
All right, so you're all set for today, Ms. Reed.
Okay, thank you so much.
Okay, so they still have brought.
Your Honor, do we have anything else?
I've got yeah, another violation of probation that should have just been sent to you. They never brought us Mr. White. Over him and Mr.
Thanks, Kelly. You have 3 rooms. Alan Whiteman. Brian Dodson. Thank you. Okay.
This is file 24-21972-FH People versus Nathan Wayne Edwards. We are here today for a hearing on Mr. Edwards' motion to correct an invalid sentence and for resentencing. We are proceeding today by video conference. Ms. Bruggeman, would you like to place your appearance on the record?
Jennifer Bruggeman on behalf of the people.
And sir, you are Nathan Wayne Edwards?
Yes, Your Honor.
All right, so Mr. Edwards, I've received your motion. I'll give you an opportunity now to say anything you'd like to in support of it.
Yes, I sent a request in for a court-appointed attorney about 2 weeks ago. I would like to request to adjourn the hearing until I'm able to consult counsel, as this is my right to be represented during a critical stage under United States versus Chronic.
So I think I've issued an order on that. I did look into that, and you're not at this point entitled to appellate counsel.
Okay, I don't know how
So
to proceed.
I think I've addressed, so you've written a motion, and I'm willing to hear your argument on that motion. So if you have any, you can make that now, or if you just want to rely on the written motion, you can do that.
Just rely on the written motion.
Okay, and Ms. Bruggeman, I've also received your reply. Is there anything that you wanted to say in addition to your reply?
No, I would just agree that, well, no, I would just rely on my answer to the motion. As far as the appellate counsel, I obviously have no
opinion on that. And leave that in the court's discretion. But as far as my answer to his motion regarding resentencing or the invalid sentence, and then the issue with regard to the plea, I would again rely on my answer to that I filed with the court.
Doesn't matter, each are the same. Okay, did anything would be right outside.
All right, Mr. Edwards has correctly pointed out that his sentence is invalid. They should not have been made consecutive. They should have been concurrent. And so it is an invalid sentence. He is entitled to resentencing. So I'm going to grant that motion, and we will set this for resentencing. So I will set that for October 2nd at 8:15 a.m.
Your Honor, do you need prosecutor's presence at that resentencing?
I don't believe it's necessary.
Okay.
Obviously, if they want to have someone there, they're welcome to.
Okay.
Mr. Edwards, I don't know off the top of my head whether the decision I've just made now entitles you to an attorney. I would think it probably does, but I will look into that. And if it's appropriate, I will appoint an attorney for you.
Thank you, Your Honor.
Okay, so you're all set for today then, Mr. Edwards.
Okay, thank you, Your Honor.
Okay, so sir, are you Mr. Dennis?
I hear you, Your Honor.
Okay. And the other gentleman at the jail, you are Mr. Whiteman?
Yes, sir.
Okay, Mr. Malero, do you need to speak to Mr. Whiteman?
Yeah, real brief, Judge. Won't take long.
Okay, so this is file 23-21255-FH, People versus Brian Matthew Dennis. We are here today for arraignment on an alleged probation violation. We're proceeding by video conference. Sir, you are Brian Matthew Dennis?
Yes, Your Honor.
Mr. Dennis, have you received a copy of the request and warrant for probation violation?
I have not received no paperwork yet. No, I did ask at the control where they told me some information about it.
Okay, we will, sir, can you take this? We'll send it over to the jail right now and have a copy of that brought to you.
Okay, is there any way I can just plead guilty to the violation and get that going?
We can talk about that. We can talk about that in a minute, but I've got to ask you some questions to make sure you understand what your rights are. We do that,
Sure.
okay?
Sure, thank you.
So while they're bringing you that copy of your warrant, I can tell you that the warrant alleges that you violated your probation by consuming alcohol on August 25, 2025. That would be just the consumption of alcohol would be a technical probation violation. There's also an allegation for a non-technical probation violation that you were arrested for OWI, operating while intoxicated, on August 25th, 2025 by the Michigan State Police.
Yes, sir.
you had previously in this case been found guilty of aggravated stalking, and the maximum possible penalty for, sorry, one second. The hell what? So the maximum possible penalty for aggravated stalking is up to 5 years in prison and or a $10,000 fine. You'd also been found guilty or pled guilty to domestic violence, and the maximum possible penalty for that offense is up to 93 days in jail and or a $500 fine. You do have the right to be represented by an attorney at this hearing here today and at any other hearings that we have regarding this matter. If you can't afford an attorney, you can tell me that and I'll appoint one for you at from the public defender's office. Do you understand that?
Yes, Your Honor.
Would you like to be represented by an attorney?
Yes, I do, but I
Your
can't
Honor.
afford one. I will not be able to afford one.
Okay, so I'll have you speak to Ms. Underwood from the public defender's office.
Thank you, Your Honor.
Give me just a moment and I will set up a breakout session.
Sure, thank you.
Okay, so if there's something on your screen, Mr. Dennis asking you to join a breakout session, click join or accept or whatever it's asking you to do. Okay, we can move to Mr. Quinn. All right, we're on the record now in file 24-22035-FH and 25-22386-FH, People versus Alan G. Whiteman. We are here today for a pretrial conference in the 24 case, an arraignment in the 25 case. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. McClure.
B.B. McClure, on behalf of the people.
Salvatore Malero on behalf of Alan Whiteman.
And sir, you are Alan Gene Whiteman.
Yes, sir, I am.
Mr. Malero, does Mr. Whiteman wish to have the information read in the 25 case?
Your Honor, at this time, we would acknowledge receipt of the information, waive its reading in open court. Mr. Whiteman will stand mute as to the count one. I do not see any habitual offender notice. Maybe, nope. And we'd further acknowledge receipt of the witness list. And we'd ask the matter be set for pretrial. And with the other case, we would ask that be adjourned out for pretrial as well.
Okay. I'll enter not guilty plea for Mr. Whiteman in the 25 case, and we can set both cases for a pretrial conference on September 24th at 8:15 a.m.
Great. Thank you, Judge.
Thank you.
Okay, Mr. Whiteman, you are all set. You can tell them that you're done with court for today.
Thank you, sir.
Thank you. Okay, and the other gentleman at the jail, you, Mr. Smith?
Yes, Your Honor.
Judge, can I do a quick breakout with Mr. Smith and then we could proceed?
Yes, yes, you can. Just 1 second. Let me get that set up. Okay, we are back on the record in People versus Brian Matthew Dennis, file 23-21255-FH. Ms. Underwood, do you want to place your appearance on the record?
Ron Underwood for Mr. Dennis this morning, Your Honor. Thank you.
Okay, and you know how Mr. Dennis wishes to proceed?
On behalf of Mr. Dennis, I would ask the court to enter a not guilty plea on his behalf. The obvious reason being, Your Honor, that there is apparently a new case, which will, I would hazard to guess, be brought against Mr. Dennis in district court. I don't have any court dates yet on that, but I would ask the court to adjourn this matter to next Wednesday, when hopefully we have more information on that. And I've explained to Mr. Dennis the dangers of proceeding on this matter prior to that matter being resolved, and his rights against self-incrimination.
Okay, so I'll enter a not guilty plea for Mr. Dennis at this point, and we can set this over to next week is September 3rd at 8:50.
Can I ask a question, please? I don't want to interrupt nobody, but the time I'm in here, will that be, so whatever happens in the future, will the time I'm sitting in here at least count for something?
Yes,
if you
receive a sentence on this case, you'll get credit from the date that you got arrested until whenever the sentencing date is. All those days will count toward any sentence you get.
Okay, thank you.
Okay. All right, so we will see you next week, and you can tell them you're all set with court for today.
What was the date? The 3rd, you said?
September 3rd. It's a week from today.
Okay, thank you.
Yep, thank you, sir. Okay.
Is that everything, Your Honor?
Okay, you don't have Michael Turner, do you?
I do not.
Okay.
Is there a button I push on here to get out of here? I don't see nobody.
You know, I don't know how those work, but we can call the jail and let them know you're done.
Okay, thank you.
We'll call, if he's done, I can take Mr. Turner.
Your Honor, Mr. Turner is my client.
Okay. All right, so this is file 25-22247-FH People versus Dustin Smith. We are here today for a pretrial conference. In this case, we're proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms.
Phoebe McClure on behalf of the people.
Salvatore Malero on behalf of Dustin Smith.
And Mr. Malero, where do we stand with Mr. Smith's case today?
Judge, we recently received the transcript of the prelim, and so we're ready to set the matter for trial. So that'd be our request.
Okay. How much time, Ms. McClure, do you think will be needed for a trial?
If defense has no witnesses, I would say a day and a half.
Okay, Mr. Malero, any idea whether that's sufficient or need more?
I'd say probably 2 days, maybe outside chance 3, but 2 for sure.
Okay. All right, so Ms. Clark, let's set it for 3 days so we're sure we have enough time. And if we don't need it, that's okay.
Wednesday, October 15th at 10:30, Thursday, October 16th at 9, and Friday, October 17th at 9.
You said the 15th through the 17th, is that correct?
Yes.
That works for me, Judge, other than on the 15th, I do have an appointment for my son. I would have to leave here by 4 p.m. So as long as the court's okay with ending early on the first day, I can make that work.
I don't have any issue with that. Mr. Miller, do you have any issue with that?
I gotta know, Judge, are you're, oh, never mind. I thought it was the circuit court judges are out, but not. Yeah, I'm available all 3 days.
Okay. So we'll set it for October 15, 16, and 17. Let's do a final pretrial on October 8th.
And the current offer that's outstanding is, and I know Mr. Bauer has spoken with Mr. Smith about this, but it is to plead to one count of accosting a one count of assault with intent to commit criminal sexual conduct second degree with no further incarceration at time of sentence. That offer will be withdrawn on October 8th at the final pretrial.
That requires registration. How long, Ms. McClure?
I believe it's the lower tier, but I can double check. It is a tier 2 offense.
All right, thank you. We'll let you know.
Okay.
Okay, so the court will issue a scheduling order with those dates in it. Mr. Smith, you can let the officer with you know that you're done with court for today.
Yeah, thank you, Your Honor.
Thank you.
Thank you, Judge.
And yeah, thank you, Mr. Malero. I think that's everything that I had for you.
I sure hope so.
And,
for your sake, Judge. For your sake, Your Honor, not mine.
I'm wearing down. We're getting to the end, but I'm wearing down.
All right. Have a good day.
Thank you. You too. And Mr. Murphy, I'll put you in a breakout session with Mr. Turner right now.
Thank you, Your Honor.
This PPO was never, the motion was never served.
No issue. Oh, that's the one.
Hold on.
Can we just put a note in it that nobody should?
Your Honor, I have down that we still have 3 pretrials. Is that correct?
No, I only have Michael Turner left. Who else do you
Oh,
have?
okay. I probably missed them, but okay, that sounds good. Just Michael Turner. I had Watson, Clark, and Dodson. They were Alex's cases though, so I may have missed them.
Yeah, we did both of those.
Yeah.
is file 25-22335-FH People versus Michael Joshua Turner. We are here today for a pretrial conference, and we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Ms. McClure.
B.B. McClure on behalf of the people.
Matthew Murphy, appearing on behalf of Mr. Turner.
And sir, you're Michael Joshua Turner?
Yes, Your Honor.
All right, Mr. Murphy, where do
Your
we
Honor,
stand?
I'm sorry, I didn't mean to interrupt. But I've been talking to communicating with Mr. Sneed about this case. The offer would be for him to plead to an attempted possession of contraband, with no habituals. From my understanding, there would be no sentencing agreement by the prosecution. The only question I was trying to figure out here is if he was to plead to that, because again, it is a prisoner in possession of a contraband. He is serving a sentence right now in Lenawee County Jail, set to be out, I believe on September 7th, and go on to probation. I wasn't sure. I was trying to figure it out. My understanding would be that it's not commanded to be consecutive, that it's optional. I wasn't sure if the court was aware, if he was to plead to that, if the court has no option but to do a consecutive sentence. And I didn't know if Mr. McClure would be able to answer that or not. Again, my hope would be that he'll be able to plead and have it be concurrent with what he's doing now. Again, out in September 7th, then about 2 more years of probation to be done. But I don't know if Your Honor will be able to give more information, or if Mr. McClure will be able to confirm that he could just agree to do a concurrent.
My understanding is it would only be consecutive if he was charged with another offense on the same complaint, or the same set of facts and circumstances.
Yeah, that was my understanding too, that it wouldn't be a situation where, whether or not it was discretionary, I didn't know, but I didn't think it was commanding the court to do consecutive. So
yeah, I believe it's only allowable if there's another offense that it arose out of the same set of facts.
Thank you. So Mr. Turner would again like to plead to an attempted possession of contraband with no habituals, if that was correct on that. Mr. Sneed had texted me saying that would be the case, but I didn't know if he put any paperwork in.
I don't have any paperwork on the plea. It would just take me a few minutes to do that.
And I was also not part of the plea, but I was going to ask to address bond after the plea was entered.
Judge, we can't hear you.
Yeah, no, sorry, we were talking about something else. So.
Oh, I'm sorry. I just saw your lips moving and I thought Zoom was glitching.
No, I was just trying to, Kelly was telling me that Ms. Holly got kicked out of the Zoom meeting for some reason and asking me to let back in. So.
I'm back. I got back on. It's been going in and out lately, like just to the end of the session.
Yeah, mine too.
Okay, so, all right, so Ms. McClure, you're preparing those documents now then?
I can, yeah. For an attempt, Matt?
Yeah, an attempted possession of contraband at the jail, 2.5 year.
All right, and so could you call the jail and have them? Mr. Turner, we're going to have someone at the jail bring to you an advice of rights form. When they bring you that, take whatever time you need to read through it. And they should bring you a pen as well. If you're comfortable with what it says in there, go ahead and sign it.
Okay. Thank you, Your Honor.
If somebody gets you that advice of rights forms, another advice of rights form, he's going to be taking a plea. And pen for him to sign it. Thank you. All right, bye.
Good morning, Miss. What's your name?
Katherine Wesley. I I've been sitting outside. I wasn't sure I was supposed to come in or not. I thought you were gonna call. 11:30.
Okay, so this is your motion to terminate personal protection order?
Yes, Your Honor.
All right, so. You can come forward and sit here at the table closer to the television. This file 25-52869-PH. Bianca Sumner versus Katherine Wesley. We are here today for a hearing on to terminate a personal protection order. We are proceeding today in person. And ma'am, you are Katherine Wesley, correct?
Correct.
All right, so looking at the file, it doesn't appear that you've properly served a copy of your motion on Ms. Sumner.
I was informed by the clerks to either do certified mail, or contact somebody that would serve her. And so I went the certified mail route, and it was delivered on the 22nd of August at 11:22 a.m. And she was the only person that could sign for it, and she didn't sign for it and has not picked it up from the post office as of yet.
So that's the issue with certified mail, is that you have to it has to be signed for, and we have to have the return of the green card that comes back with her signature on it. If she doesn't cooperate with signing it, then you have to contact a person, a process server, to go out and chase her down and hand it to her personally. So it hasn't been served as services required under the court rules. And so I can't continue to have the hearing. What I can do is.
Okay, could I say one thing? I've been contacting Lenawee Crime Stoppers for about a year regarding this case. She has a minor living at that residence.
Okay,
that's fine, Your Honor.
I can't, she doesn't, under the court rules, have notice of this hearing. And I cannot hear from you about the content of the hearing in her absence when she doesn't have notice of it. So in most court hearings, both parties have a right to be present and tell their side of the story.
Like I was supposed to be present when she put
That
the
is an
video?
exception. That's why I said most.
Okay.
Right? So,
Okay. I'm, Your Honor, I was informed through the clerk specifically how to do it, so.
Right, and you tried to do it by certified mail.
Right.
And it didn't get done.
It didn't get done, whereas she didn't sign for it.
Correct.
Okay, so who determines whether or not she signed for it or not when it got delivered that day?
The post office takes it to her house.
Right.
Gives her the green card to sign.
Right.
If she doesn't sign it, she doesn't sign it. And the court rule requires it to be signed.
Right.
So if it's not signed, it hasn't been served in accordance with the court rule. And I can't have the hearing.
Okay, so the process server will take it to her, and if she doesn't right in front of that process server sign for it, then it'll be determined that she didn't sign for it, and that will be the answer.
If the process server hands it to her, she does not have to sign for it. The process server then fills out a proof of service and files it with the court saying, I handed it to her.
Okay.
So she doesn't have to sign for it if a process server does it.
Why did they tell me to do it certified mail? And I've already paid for the certified mail, and it went to her house, and they've been informed, and they know that it's at the post office, and she never went to pick it up.
I understand that. What I need you to understand is that I can only have the hearing if we're in compliance with the rules, and we're not.
I understand that. So how do we?
Please don't interrupt me.
I apologize. So how do we move forward then, sir?
I've told you.
Okay. You told me?
Yes, you have to have a process server serve the the motion on here.
Have the money for the process server now today, and now it's like, and now I'm getting held back.
I can't help you with these issues. I can only conduct hearings that are in compliance with the court rule. We are not in compliance with the court rule right now.
Okay.
It is up to you as the litigant to get yourself into compliance. And when that happens, I will have the hearing.
Okay. Who do I report to then all of these things that are going on that the police and nobody else are taking care of over at that house? Where a minor is living?
I cannot help you.
You can't help me with that?
No.
Okay, thank you.
What I can do is provide you with another date, and if you have the motion served on her at that time, we can proceed forward at that time. So Ms. Clark, can you give us our next available Monday motion hearing date?
Yes, Judge. We could do September 8th at 11:30.
All right, so September 8th at 11:30. And if you can have a process server, have that served on her by that time, then we can go forward with the hearing.
And what if I can't locate her?
Then there's a process for alternate service.
For what is it?
Alternate service.
Okay. All right. Can I have a piece of paper with the hearing information on it, please? Is that all? Your Honor?
Pardon?
Is that all?
Yes.
Thank you so much for your time.
All right, I have the amended information now for Mr. Turner. Mr. Turner, have they brought you the advice of rights form yet?
Yes, Your Honor, and I have signed it.
Okay, thank you very much. All right, so Mr. Turner, I'll ask you to raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
And you are Michael Joshua Turner?
Yes, Your Honor.
Mr. Turner, you've heard the statement of your attorney and the prosecuting attorneys that your intention to plead guilty today to count 2, attempted prisoner possessing contraband.
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 2.5 years in prison and or a $500 fine?
Yes, Your Honor.
Are you satisfied with Mr. Murphy and the advice that he's giving you?
Yes, Your Honor.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the courts, other than as we've discussed on the record here today. Is that correct, Ms. McCool?
That is correct.
That's correct, Your Honor.
Mr. Murphy? If a guilty plea is accepted, there'll be no trial. That means that you're giving up the rights that you would have had at trial. I'm going to explain those to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Turner, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, Your Honor.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, Your Honor.
Do you understand that you're giving them up?
Yes, Your Honor.
How do you want to plead to the charge that on or about June 26, 2025, in the city of Adrian County, Illinois, state of Michigan, that you did commit the offense of attempted prisoner possessing contraband?
Guilty.
Has anybody made any threats or promises to you to induce you to plead guilty to that charge?
No, Your Honor.
Do you understand that if I accept your plea, you'll be giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record this week, or that it was not your own choice to enter plea?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Turner to plead guilty to them?
No, Your Honor.
No, Your Honor.
Mr. Turner, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, Your Honor.
If your plea is accepted and you engage in misconduct, the court is not bound by any sentencing agreement or evaluation. Misconduct includes but is not limited to absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, Your Honor.
Is it your own choice to plead guilty?
Yes, Your Honor.
Mr. Murphy, would you like to establish the factual basis?
Yes, Your Honor. Thank you. Mr. Turner, can you hear and understand me okay?
Yes.
Okay. Mr. Turner, were you indeed in the Lenawee County Jail lawfully sentenced to incarceration there on June 26, 2025?
Yes.
Okay. And as an inmate at the jail, did you have or attempt to have in your possession at that date some alcoholic beverage?
Yes.
Were you aware that it was an alcoholic beverage?
Yes.
Okay. And you're aware that that's not allowed at the Lenawee County Jail, correct?
Yes.
Your Honor, I have no further questions. I believe we satisfy the factual basis.
Satisfied, Your Honor.
Has the court complied with MCR 6.302 B, C, and D, Ms. McCrory?
It has.
Mr. Murphy?
It has, Your Honor. Thank you.
All right, I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Turner has had full knowledge of his rights. He's had competent counsel. I will refer this matter. I'm sorry. The court's not made any agreement regarding the possibility of plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for pre-sentence investigation and set sentencing for October 3rd at 8:15 a.m.
Your Honor, may I address bond, please?
Go ahead.
Your Honor, Mr. Turner, obviously, he's been incarcerated now for some time. He has a sentence he's serving. I believe, like I had said before, his sentence is due to be done on September 7th. And from my understanding, he was sentenced to 3 years of probation on top of that, meaning, he'll probably have another 2 years of probation after he's released. I'd ask the court to consider at this time changing the bond on this case for a personal recognizance bond to allow him to be released and continue on probation on that charge. Obviously, he's well aware of the fact that if he doesn't appear on the 3rd to be sentenced on this charge, the plea agreement goes out the door. Anything that we've worked out goes out the door, and we're back to the beginning where he's again charged with a 5-year felony. Now, obviously, the charge itself, I understand the court have some concern about it. Mr. Turner is taking responsibility for the issue, and I believe that, moving forward, he understands he has to abide by orders of this court and any other, institution, any other jurisdiction that he's in. He does apologize for his behavior on it, but again, I don't think he's a flight risk. And I believe he'll understand that, again, he has probation plus whatever bond conditions the court would order to abide by when he's released. So I think there'd be sufficient monitoring of him that incarceration wouldn't be necessary pending this case, the sentencing on this case. So I'd ask the court to consider, again, a PR bond that, he wouldn't be released until September 7th in either case. But I'd ask the court to consider that. Thank you.
Okay, so he is already on probation, and I don't recall what the other case was about off the top of my head, but obviously committing a crime while on probation is a violation of that probation. And so I'd like to have a more full picture when I make a decision about the bond. So I'm not inclined to reduce it to a PR bond at this point.
Thank you for taking the time.
Just because I don't know what's going to happen with the case that he's on probation. I don't recall how serious that was or what other issues might be at play there. So I'm going to deny that request at this point.
Judge, it looks like it was a felonious assault.
So again, sentencing will be October 3rd at 8:50.
Thank you, Your Honor.
All right, Mr. Attorney, you can let the officer with you know that you're done with court for today.
All right, thank you, Your Honor.
Mr. Turner,